Good afternoon, everyone. I'm Russ Feingold, President of the American Constitution Society, and I'd like to welcome you to today's discussion. I beg your pardon, executive clemency in the final days of Trump. In Federalist number 74, Alexander Hamilton wrote that the criminal code of every country partakes so much of necessary severity that without an easy access to exceptions in favor of unfortunate guilt, justice would wear a countenance too sanguinary and cruel. So was the pardon power vested in the president by Article 2 of the Constitution, meant to serve as a way to balance justice, fairness, and mercy in our criminal legal system. Now, some may, of course, quibble with Hamilton's conclusion that it is necessary for our criminal code to be so severe. But executive clemency can be a powerful tool, particularly when technical guilt fails to square with actual justice. President Carter's blanket pardon allowed tens of thousands of men who opposed the Vietnam War and evaded the draft to step out of the shadows and return to the United States as part of an effort to heal the country's enduring psychic wounds from that divisive war. And through the power of clemency, presidents have spared men from execution and commuted the sentences of thousands who were subject to racist and draconian sentencing policies. Still, advocates have rightly criticized presidential administrations for not using executive clemency more aggressively to address the inequities in our criminal legal system. And of course, there have been controversial uses of the pardon in the past as well, which brings us to President Trump doling out of pardons and commutations, largely to political allies. He has granted just 26 pardons, starting with the infamous former Sheriff Joe Arpaio, and most recently, his disgraced former National Security Advisor Michael Flynn. He's granted only 16 commutations, including former Illinois governor and celebrity apprentice contestant Braga Blagojevich and close friend and advisor Roger Stone. With the end of his presidency fast approaching, we're watching expectantly to see who else he might pardon. Rudy Giuliani, his children, himself. Today's speakers will illuminate the law and policies underlying the pardon power, the concerns about President Trump's potential grants in the waning days of his administration, and what the Biden administration might do to realize the true potential of executive clemency. So I'd now like to turn it over to Kimberly Atkins, senior opinion writer for the Boston Globe, contributor to MSNBC, and good friend of ACS, who will lead our discussion today. You're on mute, Kimberly.
Oops. Can you hear me now?
Yes.
This is our new world. Thank you so much to all of you for joining us, and thanks, Russ, for the introduction. Before we get started in our conversation, I just wanted to have a few notes for all of our audience members. Today's call is being recorded, and the recorded will be available after the call on ACS's website, www.acslaw.org. And we will be taking questions that I will pose to the panel members at the end of our discussion. If you'd like to ask a question, you can use the Q&A feature, the Q&A box at the bottom of your screen at any time during the call, and I will get to as many of them as I can at the end of the program. Please don't use the chat function because then I won't see your question. And finally, 1 hour of California CLE credit is available for this call. Please email info@acslaw.org with "I beg your pardon" in the subject line to receive your CLE credit. If you are seeking CLE credit for another jurisdiction, please consult the rules of the state's CLE board as it provides for reciprocity with California. CLE materials can be found on the event page of the ACS website, which is again acslaw.org, and will be shared with all participants in an email after this event. And with that, I'm happy to introduce our panelists for this discussion on executive clemency. Rachel Barco is Vice Dean and Siegel Family Professor of Regulatory Law and Policy and Faculty Director at the Center on the Administration of Criminal Law with New York University Law School. Her scholarship focuses on applying the lessons and theories of administrative and constitutional law to the administration of criminal justice. Thanks for joining us, Rachel. And Larry Coopers of Cooper's Law served as acting pardon attorney with the U.S. Department of Justice's Office of the Pardon Attorney. And he also served as deputy pardon attorney there. He is a former federal public defender who joined the Pardon Office as a senior attorney in 2014. Larry, thank you for joining us as well.
Thank you, Kim.
So I want to kick off the discussion about the executive power as Russ described it, that goes back to the founders, goes back to Hamilton. And the idea was not only is to serve as a way to correct overly severe criminal punishments, but also as a way for reconciliation. And we've seen the pardon power used in both ways. Before we get into the specifics of the Trump administration, let's talk a little bit more generally so we remember why the pardon power is there in the first place. And Rachel, I'll start with you.
Okay, thanks. Thanks for having me today. I'm glad you wanted to start there, because my great fear through all of this is that people will look and see the abuse of the power by Trump and ask, why does this crazy authority exist? It seems arbitrary. In fact, it's really critical because every law, no matter how carefully written, is overbroad in its application in particular cases, and it produces unjust outcomes. And the framers knew that, and they wanted a mechanism in place that the executive would have to correct that, to correct when the legislature went too far, to correct when the judiciary went too far with an excessively long sentence, and even to correct within the executive branch itself when prosecutors pursued charges that were too extreme. So this mechanism lets the president reduce somebody's sentence or give them an outright pardon and clear a record. And it's particularly important today to have something like that in place when you're talking about an enormous number of people who have federal convictions and are serving federal sentences in federal prisons. They don't have other mechanisms in place to seek relief. We don't have parole. You can't just get a second look by a parole authority. If you want to get your sentence reduced, you have to ask the President of the United States to do it. If you want to clear your record, there's no mechanism at the federal level to expunge that. You have to get a pardon. So it's this really important corrective measure that has taken on even more importance in an era of mass incarceration. And so having it used well by someone with good character and judgment is actually a really critical part of the constitutional design.
Larry, what do you have to add to that about the purpose of the pardon power?
Well, I would just add this, a couple things. First of all, what Rachel says is absolutely right. There's been an historical opposition to a clemency power. Two of the most famous philosophers in the history of Western thought, Immanuel Kant from Germany and Jeremy Bentham from England, both thought that there was no need for a clemency power, because if a criminal justice system worked effectively, the sentences would be fair and proportionate, and the pardon power would just be useless or futile. That turns out not to be the case, and happily, one of our framers, Alexander Hamilton, knew that it would not work that way, that all justice systems have real deficiencies, and so you need some sort of corrective mechanism. And as Rachel says, we need the fair and efficient implementation of the pardon power by the incoming president more than ever, because, for example, the past two laws that were passed, one by the Obama administration, one by the Trump administration, are laws that correct the severity of federal sentencing, but they don't apply to people who have already been sentenced before the time the law was enacted. So these are people who are serving a sentence which, if they were now sentenced, would be much lower, and yet they face the extra time in prison. And that's exactly a function of the pardon power is to look at these disparities and severities of sentencing and correct them.
And Larry, I want to stick with you for a moment, since you worked in the office of the pardon attorney in both the Obama administration and the Trump administration, and you were witness to how it changed. Talk a little bit about how the role in vetting clemency requests was moved more from the purview of the Justice Department into the White House, and the impact you think that that has made.
It was quite a shift to go from the Obama administration to the Trump administration. Obama had done something historical by initiating the clemency campaign or initiative under AG Eric Holder that resulted in 1,700 commutations. And you have to remember that the commutations and pardons are different. Pardons apply most of the time to people after they've been convicted to restore some rights. Commutations actually reduce prison sentences, which means that commutations lead to people getting out of prison early. And so for a president to do a commutation is to take a risk, because the person getting out early could somehow go sideways and commit crimes, and then it all falls back on the president. And yet President Obama signed off on over 1,700, which was historically unprecedented. We turned then to the Trump administration, and I was leading the office at that point. And what happened was a complete breakdown of the process. Basically, DOJ's part in gathering petitions, evaluating them, and making careful recommendations to the White House all went sideways, because President Trump simply exercised the power from the White House. And you can see in the public record that most of his clemency grants did not go through DOJ. There was just not a process or not the continuation of a process that had been worked out for years, where things went through DOJ, the president gets a recommendation, then the president acts on it. No, this was a matter of just granting benefits to basically to cronies and to people who his base would get excited about.
And Rachel, I want to ask you about the breadth of this power, which as it shifted from DOJ to the White House and has been used primarily, as Larry pointed out, for allies of the president during his administration. And reportedly he's considering using it for his family members and for himself. We're going to talk about the self-pardon power a little later on in our discussion, but how far can it go? Can grants of clemency be made for all offenses? Are they for specific offenses on the federal level? Can it apply to the future? How broad might some of these pardons that the president could give, how far can they reach?
It's a sweeping power. So it applies to all federal offenses, except for cases of impeachment. And it includes any past conduct that could be charged criminally. So it doesn't apply to future conduct. It's not like a card you can give one that says, you know, have a good 2021, commit whatever crime you want. But anything you've done in the past that could be the basis for a federal criminal charge is something that the president could pardon, could give a clemency grant for, and immunize you from facing punishment as a result of that. So it's when people say a preemptive pardon, they're referring to that kind of idea. It hasn't been charged yet, but you know, foreseeably could be charged in the future. You can pardon, but again, it just has to be conduct that's already occurred. So that's pretty sweeping. It doesn't include state charges. So if you have criminal conduct that someone engages in that could be the basis for either a federal charge or a state charge, and there's all kinds of things that are overlapping like that, you know, various frauds and the like. The only thing the president can give clemency to is a federal charge. So if state prosecutors want to go ahead and pursue that exact same person with state charges, they can still do that. And the president doesn't have any power to stop that from happening with the clemency grant. So it's sweeping, so the answers to most of the questions people are asking these days, like, can he do that? Can he give it to his own children? Yes. Can he give it to his political allies? Yes. So it's really broad. I think the shame in that is, the idea that someone on their way out of the presidency would be thinking about the most grotesque self-interested use of this power when there's a backlog of about 13,000 people who dutifully filed petitions, followed the rules of process, have been waiting in a very long line to be considered, who are currently in federal prisons. There's so many meritorious cases. At NYU, we worked pretty hard during the Obama initiative on cases, and we got 94 grants, but we got so many denials and so many people that we just never heard back from. We just never heard back from the administration on, that just stayed in the queue wherever they were, and they just kind of vanished, those petitions. We never heard anything from the Trump administration. And I take it from Larry's answer, part of that problem was that it was like the DOJ part of the process just got shut out, and it became this weird satellite, arbitrary, off the cuff kind of whatever Trump happened to see on Fox that day kind of process. And so it's really the juxtaposition that you would be thinking about a kind of preemptive grant for your kid when we're talking about thousands of people. I should also just add, there's a real racial justice dimension to all this as well. If you look at the grants that Trump has given, they skew heavily towards, very well off white people. That is not what our federal prison population looks like. It is made up predominantly of people of color, and they have just been glaringly absent from his grants, just a handful. So it's in addition to the fact that it's been biased toward people he knows and cronies, I just wanted to also bring up that it has that skew in terms of racial demographics as well.
And Larry, I want to ask you about that issue too, an issue of access, essentially, to this clemency, whether it's people who Trump knows, people in his inner circle, to celebrities like Kim Kardashian, who has made this her cause celeb, and who has worked to get pardons on behalf of other people. How big of an issue is that access, and how does that look different with the Justice Department as opposed to when the decision is being made primarily from the White House?
Well, unfortunately, I can't tell you much about it. It's something like a black box to think about all the grants that came from the White House without going through DOJ. Where did they come from? Did they come from some influential donors of Trump? We know one came from Kim Kardashian, and she's sitting in the Oval Office with the president, and all of a sudden somebody is commuted. So where all that came from, that's the whole point of having it go through the DOJ, is that you have an impartial, fair process with DOJ and up to the White House. If it doesn't go that way, then who knows where the influences came. And now we have a scandal going about some pay for pardon allegations, and we'll see how that works out. But I should say it's an absolute shame that so many people, many meritorious applicants, are being ignored while these cronies of Trump are getting attention. And when Rachel talks about the racial inequity, the irony is that the one clemency grant, or one of the clemency grants that Trump gave, was to Jack Johnson, the famous heavyweight champion. So there you have a black man who's dead, and now he's getting the benefit of a clemency grant. I should say, we're going to get around to this, so I should say, to add to Rachel's remarks, that not only is the pardon power virtually unbounded, but that it's been that way from the very start, because in the Constitutional Convention, they actually argued over whether the Senate should have to approve of the president's grants of clemency, and that was rejected. Then you get a series of court decisions that said, we leave the president to do as he or she wants. That's it. And there has never been in the history of this country that I'm aware of any court overturning a grant of clemency. The first one might be if Trump pardons himself, because all of a sudden that might be a grant that that the court would want to get involved in. There's also a case in California, well, not California, in the Ninth Circuit Court of Appeals on the Joe Arpaio clemency grant, where arguments were made in the district court that this grant was improper and illegitimate because it took away a very essential function of the court to deal with people who do not obey court orders, because that's basically what Joe Arpaio got convicted of. And the district court judge did not buy that argument, but it's up at the Ninth Circuit now. But again, that would be the first time, if the court bought that argument, that a clemency grant was overturned.
Can I just say one thing?
Yes,
Kimberly,
please.
I just want to jump in on one point, which is that, so I think it's important to note that we lack these checks on a president's grant of clemency, but there's actually a way in which Congress could step in and correct for another misuse of the power, which is its disuse. You know, I think if Congress tends to get all riled up about the cases where the president gives a grant and, you know, it's a crony, it looks awful. I would like them to be as angry at the president for not giving grants, you know, for that backlog. And that is actually something Congress could fix, because it's not an exclusive power to the president to be merciful or take a second look at sentences. Congress could create other mechanisms to do that. Congress could create a mechanism where somebody could get their record expunged and it would have the same effect as a pardon. You know, Congress could create a mechanism to get a second look at your sentence to get it reduced. It could put that in the judiciary. It could give it to some other independent body if it wants to. All that is fair game. So there's lots of room to be merciful if there was a political will to do it. What there isn't an ability to check is if the president gives grants of clemency. But I would hope that we would see as much outrage and anger at the fact that he's not using the authority for the people who deserve it. And that one can be fixed. You know, that's something that Congress could step in and fill that gap. And then it becomes far less important when a president doesn't give relief, because you'd have these other places that people could go. So, you know, we're really talking about a one-way ratchet of unreviewable authority, and it's just when the president, you know, decides to be merciful, decides to be lenient and give somebody that benefit, but not in a case where the president's not using it. We could have all kinds of alternatives in place, and I really hope we get to a point where Congress thinks seriously about doing that.
And Kimberly, I agree entirely. In fact, I think clemency, it should always be considered an important component of criminal justice reform. But I think Congress has to take the lead role. I mean, the best that clemency can do is something like the commutations we did under President Obama. We're not talking about large numbers. Whereas, as Rachel's saying, if you pass a Second Look Act that gave everybody who's sentenced to over 15 years or over 20 years a chance to come back before the judge for a second look at the severity of the sentence and a look at what the person has done since being sentenced and imprisoned, because that person may have fully rehabilitated, and give the judge the power to say, okay, you know something, you don't need to serve more time. I'm going to order you released. And that's being done in some compassionate release cases, but they're somewhat narrowly defined parameters to the federal compassionate release statute.
Although my hope is that, I think it'd be great if Congress does that, assuming they won't, which I think is a safe assumption. You know, I should just say to President Biden, you actually do have the authority to go bold. And I would definitely not look at the Obama experience as a ceiling of what could be done. There were many of us who had urged far bigger, bolder grants that I think are feasible and definitely something that we could see. And I hope we do, because I think clemency actually in the next administration may be the only viable option for significant criminal justice reform, given where the Senate looks like it might be going. And if that's true, I think it's all the more urgent that, you know, President-elect Biden really think about how he wants to set things up and implement things so that he has the capacity to grant thousands, which I think is actually should be the target number. We should be thinking, you know, really, you know, tens of thousands. There are so many grants that should be coming down the pipeline. And so I don't want to kind of diminish expectations. I think they should be quite high for him.
Well, one way of doing that would be to have the president do categorical grants of clemency, which hasn't been done, which was not something any administration I've seen wanted to do. It's been done in terms of amnesties under President Ford, under President Carter. It was done under President Johnson at the end of the Civil War. It can be done, but that takes some boldness. And believe me, some of those ideas were being discussed when I was in the office, but never came to fruition. And it's going to take a bold president to do that.
And what are some other ways that the system could be reformed, and where do those reforms come from? We were talking about things that an administration can do on its own initiative. What about the role of Congress? I mean, I get that the constitutional pardon authority of the president is very expansive, but is there a way to fix the process even? Can Congress require that DOJ have a role in it? Can Congress set up some other system by which things are, clemency applications are vetted, even in leaving the final decision with the president? How does that look?
Quick answer, no. The Congress cannot do that. It always tickles me to see the different people in Congress saying, oh, we've got to do something about the clemency process. I'm with Rachel. They need to do something about passing new criminal justice reform laws. But the president's going to have to be the one to use the clemency power in a forceful way if that's going to really work. And to me, it's still only going to be part of the solution. You've got to look to congressional reform, and it's time to do it. It's time for the reckoning now.
Okay. Well, I want to get back a little bit to where some of the limitations on the executive may be. While that power is quite expansive, there are some limitations. I mean, for example, there was a story just last week about a DOJ investigation into claims that the pardon power was attempted to be traded in exchange for campaign contributions or other things. Might other laws, bribery laws, other ethical rules come into play with just how the pardon process plays out? Rachel?
Well,
I'm sorry.
go ahead.
I was going to say, you know, it is possible for an executive to misuse executive powers in such a way that it rises to the level of criminal activity. And it's also possible for people to, you know, seek things from an office holder that rises to the level of corruption and bribery. And so that's true if we're talking about someone who wants to kind of pay for play and tries to buy a pardon. You know, that can be the basis for criminal behavior. But that's a different question than can you undo a pardon that has been given to somebody, or can you undo a commutation that somebody gets? And I think people are kind of confusing those two concepts, because if the president gives a clemency grant to somebody, I am unaware, and Larry, you can tell me, of a court undoing that, right? If the president is a valid office holder at the time that grant is given, good luck undoing it. You know, could you potentially seek, if the person that got it paid for it, you know, could you seek a bribery action against that person? Absolutely. and it could be a basis of a separate criminal charge. But these kinds of things don't undo that clemency power at its root. And so that is still just going to be as robust as it always has been.
Well, one of the interesting things about this issue with Trump pardoning himself is that I believe if he did pardon himself, he would be getting himself into a federal prosecution. That is, the Justice Department might be deciding we're not going to prosecute President Trump on crimes he committed during his time in office because we want civility. We want the new administration to go forward on their program. But then if this president says, I'm pardoning myself, and that goes so counter to a fundamental premise of our system that you don't judge yourself. You can't be the judge in your own case. Then what he's going to do is prompt the Department of Justice to prosecute him in order to test that pardon. And it will go to the Supreme Court. And I would predict the Supreme Court would overturn that pardon. And Rachel, that would be the first time in history that a court has overturned a pardon. And so President Trump would be shooting himself in the foot by pardoning himself, in my opinion.
I want to get Rachel's thoughts on that, but before I do, I just want to remind our audience that if you have a question, we will save some time at the end for questions. You can type your question in the Q&A box. Do not use the chat feature. I won't see that, but if you put it in the Q&A box, I will, and we will get to as many as possible. And Larry just teed up the next issue I wanted to get to, which is the potential that the president may try to pardon himself. I want to back up just a little bit, just to say, what do we know about the constitutional ability of the president to do that, since it's never been done before? Rachel, you take it away.
So, so one of the reasons why we haven't seen anything, a pardon overturned, is that typically no one would have standing to challenge a pardon, right? So in constitutional parlance, no one would have an individual injury to be able to go into court and say, I am uniquely injured by this grant of clemency that you gave to person A, because that would be thrown out, because the court would say, look, a citizen that's upset about the grant of a pardon doesn't stand in a different position from any other citizen to raise that. It's a generalized grievance, and therefore there's no standing, and you don't get the case teed up. And so Larry is right that the way a case would get teed up is if someone were to get a pardon or a clemency, but would be prosecuted anyways. And then at that point, the government brings the prosecution, and the person would say, but look, I have this pardon. So if that person were Trump, that's how it would come up, is a new Department of Justice comes in, brings an action against him, and he says, but I pardoned myself beforehand. And he would have standing. That one would be a justiciable case. So the question is, what would the Supreme Court do about it? So I've read, not all, but a fair chunk of the scholarly articles trying to analyze the text of the constitutional provision. I think there are decent textual arguments on both sides. So I have seen arguments that say that the way the constitutional language is written is it's a grant of a pardon, and the language of grant inherently connotes two different parties, one person granting to another, and the idea of a self-grant is linguistically forced, such that the framer's language doesn't fit a self-pardon. That's not a bad argument. I've also seen a textualist argument, though, that suggests that it's this sweeping power that covers everything but an impeachment. And if you think that the framers' vision was that should a president misbehave, the way that a president would be checked would be impeachment, they'd already corrected for self-dealing, because they said you couldn't get yourself out of an impeachment. And so then it's a kind of self-contained universe that says, you don't like what the president is doing, you impeach that person, and he can't pardon himself from that. Whereas criminal charges might have seemed more foreign to them. And so, then you get arguments that just basic rule of law notions. People shouldn't be a judge in their own cause. Which is why I don't want the Department of Justice to rule on clemency petitions. But the idea is that, you shouldn't be the one to make an assessment of your own case. And obviously that's what a self-pardon is. And, that's a pretty bedrock rule of law. You can find it all over common law literature. So originalists on the court might be persuaded by that. But I'm actually not sure how the Supreme Court would decide. I think it's a close one. I really do. And particularly when we're talking about strong executive power enthusiasts among this particular group of justices. And the language has that everything but impeachment quality to it. I'm not sure they would invalidate self-pardon. I'm really not. But I think this one is a really close call, and it's very hard to predict how the court would come out.
And Larry, I want to throw it back to you, keeping in mind too that we have a Supreme Court that has more and more justices who strictly interpret the language of the Constitution. How might that weigh into a consideration of a self-pardon?
Well, I think as Rachel was saying, it makes for a very difficult case both ways. But plain language, original interpretation of the Constitution might go, there's nothing said that limits the president from pardoning himself, therefore he can pardon himself. The case against it, and Rachel made some good points, basically the idea is that there are other parts of the Constitution that are so inconsistent with the president pardoning himself that it would be illegitimate for him to do so. I'll give you an example. Some people have argued, well, there would be a pardon that was overturned if the president said, I'm going to grant commutations only to white males. And then 2 days later, you see 20 commutation grants to white males. Now, equal protection, due process, that's going to be what we consider constitutional violations. Would that be enough for a court to come in and overrule the president's pardon? Maybe, if it was that blatant and that much of a constitutional violation, or if something was so clearly corrupt, where we had evidence that the president did grant a pardon on the basis of being paid for it, on some quid pro quo. But it's very difficult. I would just bet my money that the Supreme Court would overturn a self-pardon, but I can see it going both ways. I agree with Rachel on that.
Now, there is potentially another avenue for President Trump to receive a pardon, and that is if in the waning days of the administration, he steps down and is granted a pardon by then President Mike Pence. We already know that President-elect Joe Biden has said that he has no intention to pardon Donald Trump. But let's talk a little bit about pardoning of a president. A president was pardoned in the past, Richard Nixon, and that was done based on this other principle that Hamilton talked about in the pardon power, which is for reconciliation. President Ford thought that it was more important in the interest of protecting unity in the country than prosecuting this one man. Do you think those principles are still in play? Are the current circumstances different to you? Larry, what do you think?
I think the current circumstances are different. I think those principles are still in play. Gerald Ford, by most people's views, lost the presidency, lost the next election because of his pardon of Richard Nixon. But he had reasoned that out. And if you read the text of the warrant by which he pardoned President Nixon, it was very thoughtful. This would be different because here there are multiple felony crimes that this president has committed. And the notion of reconciliation through pardoning him doesn't ring true to me. In fact, I think we'd have more reconciliation if he was prosecuted federally. So I think it's a different circumstance, but he could definitely step down. I'm not sure he has the ability to do that, but he could definitely step down and let Vice President Pence step up. And then it would be a suspicion that he made a deal with Vice President Pence, that he's allowing him the presidency in order to pardon Trump, and we'd all be suspicious of that. Would it get overturned? Probably not. Probably not.
What do you think, Rachel?
You know, I think that the biggest need for the country right now is protecting foundational democratic principles, including respect for the rule of law and the democratic republic that we have. And I can understand at different points in history, there have been different priorities in terms of what an administration is thinking about. But to my mind, the greatest threat we have seen is to the very structure of our government itself. And I think the things we witness every single day from Trump are so offensive to core democratic values that this would not be an act of national healing to give him a free pass. And instead, it would in some ways be the appeasement of a would-be authoritarian dictator. So I don't think it would have that desired effect if that were the goal. You know, I very much respect the norm of not using the criminal justice process to air out political disputes. We don't want to become some kind of banana republic where one political party in political power just goes ahead and prosecutes their opponents. It's a really dangerous precedent, and I think one would need to be really careful before going forward for just that reason, that these should be political questions that are decided at the ballot box. But I think what we've seen is a desire on the part of this administration to stymie investigations. You know, I've read the Mueller report. It's very long, but if you read it all, what you realize is that, you know, there was a real obstruction into a real investigation of what happened. There was no exoneration there, just the opposite. It was a real call for someone else to take a close look at this when you didn't have a president in power who was dangling pardons in front of people, thereby making it so that they wouldn't speak to the people doing the investigation. So, you know, I think what needs to happen is there needs to be a full investigation. I don't know that it needs to lead to a prosecution. There may be another mechanism to just get the truth out there. But I think an advanced pardon would send the absolute worst possible signal, which is that we're not even going to look into this, you know. And I think we just I want to just remind everybody that, you know, the Senate just failed utterly in its responsibility to do that investigation, to really look closely at what had happened. And I think, you know, when you look at other regimes that think about truth and reconciliation and how you bring a country together, it requires first and foremost truth, which means you have to do an investigation. You have to find out what happened. So anything that would be designed to short circuit that through the clemency power, I think would be just the opposite of a kind of healing and uniting action. I think it would spark real distrust and real concerns among people.
And my last question before we get to our audience questions goes back to solutions and remedies. We were talking about the fact that would lie in the Biden administration next. What sort of things might the administration do that Congress cannot to set up some guardrails around the clemency power itself and how it's administered? Transferring, obviously, that power back to the Justice Department would be one, but what else might that look like, Larry?
Well, I'm hearing actually that there's a possibility of instituting another clemency initiative under President Biden's administration, and that's good news to me. And that's what you're going to need. I mean, one of the things that people don't realize about the first clemency initiative is that it was part of an even larger criminal justice reform program that was called Smart on Crime, that Attorney General Eric Holder initiated, and that was specifically addressed to racial inequities in our justice system, to over severity, and even to the idea that we spend too much money imprisoning certain people so that we don't have money left to actually do good investigation and prosecution of the people who need to be put in prison. So the clemency initiative was only one part of that, but an important part. They need to reinstitute the clemency initiative. Now, it has to go back, in my mind, to the Department of Justice in terms of a process that gets to the White House. But what's important to me is that there is an inherent conflict in giving the upper levels of the Justice Department veto power over the recommendations that the pardon attorney makes to the White House. And so my proposal would be, and I know some people, and Rachel's one, would like an independent commission in order to avoid the problem of the conflict. But my proposal would be to reroute the delegation of authority such that the pardon attorney's recommendations go straight to the president without having been reviewed either by the attorney general or the deputy attorney general, and possibly vetoed by those people, and instead goes straight to the White House because the president picks a pardon attorney that he has faith in, that he has confidence in the accuracy and the fairness of the recommendations made, and then we'll listen to that pardon attorney, and things will go faster. You'll cut out levels of review, and if you take the pardon attorney and allow him or her to take part in discussions of what sort of criteria you're going to use for the clemency initiative, you can come up with a clemency initiative that's really going to give many more meritorious inmates a chance of commutation. And I agree with Rachel. We should have had more commutations during the Obama administration, and we can do it now.
Yeah.
So it's all an as, yeah. So, it's all an as compared to what kind of thing. So, certainly when you see what we've witnessed in the Trump administration, absolutely, I would take a regular process that obeys certain norms in the Department of Justice. But I think we can do much better than that. I really do. And I think that, I like Larry's idea to take the deputy attorney general and the higher levels of DOJ out of things, because we know that was a place where there were a whole lot of no's. If you want, we don't know all the details. So I don't know from the outside, but we have some indicators. From former pardon attorney Deborah Leff had indicated that she had quite a few cases that she wanted to recommend grants to, and they just stalled in the deputy attorney general's office. So, and when you think about the design of our government, the deputy attorney general is basically in charge of all criminal prosecutions. And so you are asking the head fox which of the hens should leave the hen house, right? And the process itself, one of the first things the Department of Justice does is ask the office that prosecuted the case in the first place, hey, what do you think? That is just a crazy setup for taking an objective second look at a case. So I think we agree, Larry and I, that the key thing that needs to happen is you need an objective person looking at the case without the skew of being a prosecutor, of thinking that you're on the prosecutor's team, of being the prosecutor's supervisor, all those cultural biases. I like the model of an advisory body as opposed to a single pardon attorney. And the reason I like the idea of a, you call it a commission, a board, a body, I don't care what, but the idea of having multiple people be part of it as opposed to just a single pardon attorney could really help a president out by giving some political cover, because you could create a body that has bipartisan composition, that has a formerly incarcerated person on it, that has just a variety of interests within that group, such that when they recommend a grant and the president takes that recommendation, it gives the president a little bit more than just, well, the pardon attorney did it. Because if you say it's the pardon attorney and the pardon attorney was given the orders basically from the president about what, he or she wanted to do, that's all on the president. But if you create this kind of board commission model, it actually can create some of a political buffer, because as Larry pointed out, it's a very brave action for an executive to give especially commutations. You're letting somebody out of prison earlier than they otherwise would have been. And if, heaven forbid, they commit a crime after they've been released that makes the papers, that is an act of violence, it's bad. We have seen around the country time and time again, it destroys political careers. It destroys whatever mechanisms were in place that allowed it to happen, whether it's parole, whether it's furloughs, whether it's clemency. It's the ghost of Willie Horton has just cast a long shadow over these decisions. And so one of the benefits of thinking about new models for this is, how do you also help a president to have a little bit of political cover? But, I very much trust the process of the people in the pardon attorney's office to, dutifully investigate, do the kinds of things that you would want, make sure somebody's record while they're incarcerated. You want to look and see were there any kind of red flags with discipline and the like. But I really do think we need a process in place where the person making the recommendation or the body making the recommendation to the president is neutral and doesn't have that pro-prosecution tilt. And for my money, I like a multi-member body because I think it can be designed in a way that gives the president not only good advice, but a little bit of political insulation.
Okay, I want to get to some of the questions that we've had submitted in our final minutes here. One of them is, how does a federal pardon affect the privilege against self-incrimination if one is later charged with a state crime? How does that work, Rachel?
So if you plead the fifth and you're facing state charges for whatever it is you would talk about, you don't have to incriminate yourself in that state proceeding. So it's only going to help you if it was a federal investigation and you had been fully immunized from federal prosecution. Then you can't plead the fifth in that context, and would have to be specific to whatever the federal charges were that were the subject matter of the pardon. So if it was, it doesn't. So it won't be a way to get someone, to force someone to speak freely so that you have the basis for a state prosecution. They could absolutely still plead their Fifth Amendment rights validly. And even in the context of a federal investigation, you'd need to make sure that it was only covering the things that the pardon covered, as opposed to, like I said, that kind of future conduct. If, say, it was an ongoing conspiracy, that kind of thing. So it's a fairly limited value in terms of overcoming a Fifth Amendment claim. You're still going to see plenty of people be able to make valid Fifth Amendment rights against self-incrimination.
Okay, sort of on similar grounds, this question says, isn't a pardon an admission of guilt? So if Trump pardons himself, would he be admitting he had committed crimes? Larry?
Well, that's a good question. And some people take the Supreme Court's view to be that when you accept a pardon, you are basically admitting guilt. And that's a 1916 case called Verdict. But that is debated. It's not clear that a pardon is an admission of guilt. There's no requirement. The Justice Department criteria consider your admission of guilt to be a factor that could be favorable in a pardon application, but you could pardon somebody who's claiming actual innocence. And in fact, the DOJ criteria say, well, if somebody's claiming actual innocence as the reason for a pardon, they have a burden on them, a greater burden on them. But as I say, some people take that old Supreme Court case to mean it's an admission of guilt, but I don't think that's clear at all. It's debated now quite heavily.
We have a question based on our discussion with Rachel about other limits, such as crimes that might be implicated if someone tries to buy a pardon. The question is the act of buying a pardon a future act that would not be covered by the pardon? You see how complicated this can get.
Yeah, so it all depends on how the pardon warrant itself is written. So, like, if you look at the pardon of Nixon, which is the broadest one that I've seen, it covers anything during a period of time. It's any activity under a these dates to these dates kind of a setup. So if you had a president that on the last day gave a pardon to someone that said, for any criminal activity that took place between date 1 to January 20th, 2021, and the bribe took place during that period, that would be pardoned. Now, if it took place after that dated period, then it wouldn't be covered. And similarly, if you had a pardon grant that wasn't that kind of expansive, anything that happens between this date and that date, but was instead specific to a particular course of action that didn't include the bribe, then it wouldn't cover that. So it's all about how the pardon itself is written. And so it really would depend. It would depend on how it's written, and it would depend on the timing of the bribe. But I think one thing that's important is, at least for some of the things that the kind of would-be pardons that we're thinking might be coming down the pipeline that involve, the children and the cronies. If some of those things involve ongoing conspiracies and they kind of continue to engage in criminal activity after the date of the pardon, those things that happen after the date of the pardon wouldn't be covered. So for the bribe, it would all depend on when was it.
And this is going to make for some interesting reading, because when you look at the warrants they write, say for the president's children, what time period are they going to cover? First of all, if, as Rachel's saying, if you're doing a time period as they did with Richard Nixon, you're already making a very broad pardon. But if you do one as Trump may have to do with his children, it may have to go back before the administration to 2012 or so, which, because some crimes have a statute of limitations that goes well into the next decade. And so it's almost an indication of guilt right there in the way they write the warrant.
Yeah, and Larry, talk a little bit more about that, because we also have a couple questions that ask, in the case of his children or others, would each crime have to be specified? Could you do a period of time? How might that warrant be written? We know that it can't be prospective, it can't be for future crimes,
right.
But how might that warrant be written to cover as much activity as possible?
By doing a period of time, it's going to cover any federal crimes that were committed. But as we've said, any grants of clemency has to be looking at what's already been done. It can't be you're okay if in 2024 you commit this crime. It can't be that. It has to be that the crimes were already committed. That's clear Supreme Court law. But if you do a period of time, then the scope of the pardon is, and remember, we're talking about, Rachel said, a preemptive pardon. This is what we're talking about. That is, we're pardoning before there's even a prosecution.
Right. So
it's already something that's really quite expansive. And if you're talking about a long period of time, it's very expansive. You're giving that person a big break.
And we only have a moment or two left, and I want to quickly ask the last question, which is, can the pardon power be changed with an amendment to the Constitution? Of course, it's not an easy thing to do, but is that the only way, the role Congress could have?
That's the only way, but it could be changed with an amendment to the Constitution. We're not going to get there very soon.
Right, but I will say, just to reiterate, because I really am going to keep, I'm going to keep pulling it. What Congress can change right now without a constitutional amendment are mechanisms that operate exactly like pardons and commutations do, and there's nothing to stop them from doing that. So we could reach all those people who should be getting them. That they could fix right away without any constitutional amendment required.
All right, well, that hour went by very quickly. On behalf of ACS, I would like to thank Rachel Barkow and Larry Coopers for this really timely and enlightening discussion about the clemency power. Thank you so much for joining us. And thanks to all of our audience for joining us. Again, this video will be available on ACS's website afterwards, and you can also find information there about California CLE credit. Thanks so much for joining us, and have a great day.
Thanks.